afternoon. We know everybody is very busy these days, given the current circumstances going on across the globe. So we certainly appreciate you taking the time to attend. I am in the Nashville office of Nelson Mullins. The webinar we're going to present today, Navigating the Legal, Economic, and Business Challenges of the Coronavirus Pandemic, is the second installment in a series of webinars that the firm has presented. We will have additional content, most likely coming out, additional webinars next week, and we'll be updating our website and sending out alerts as they become available. So please be on the lookout, and please attend as you are able. Nelson Mullins, very quickly, we are a full-service law firm, AmLaw 69 law firm. We have 25 offices in 11 states and the District of Columbia. I am in the Nashville office. The presentation today, we're going to have three parts. The first section is on force majeure and contract issues related to non-performance, defenses, etc. We're also going to have an update on employer obligations resulting from recent legislation in response to COVID-19, and then a discussion on some financial insights related to borrowers and lenders. And the speakers for each section will introduce themselves as we get to it. Certainly happy to answer any questions. We are, with the way the webinar is set up, if you would like a question answered, please type it in, send it in, and the moderator will let us know about the questions. Last order of business as well, for CLE credit for today, there's going to be two passwords given out. The first one is COVID, COVID. So you'll need that for CLE credit. And then the second password will be given later on in the presentation. Starting off, so my partner Mark VanderBroek and I are going to spend about 30 minutes or so here talking about business continuity, force majeure, and contractual defenses. We're getting a lot of questions, very naturally, as COVID and the pandemic are affecting business. We're getting a lot of questions on contract interpretation, contract enforcement, and very naturally, a lot of those are directly targeted at force majeure clauses and potential defenses as a matter of law. Alice, can you go to the next slide? Thank you. So with respect to business continuity, we're going to cover a few things: force majeure, other related defenses to contractual non-performance that are not in the contract. So what rights, remedies do you have as a matter of law? Rights and remedies in the contract, and as well as those at law, and then some practical considerations in drafting your force majeure provisions in your contract and helping your clients in interpretation on when somebody asks a question about the contract and working through those clauses. So generally speaking, what is a force majeure? So definition is unforeseen circumstances outside a party's control which prevents it from performing its contractual obligations. The definition sounds short and sweet, but as I'm sure all of us are coming to find, and we'll discuss here, it is a definition with a lot of room for interpretation and is not clear-cut across most of the jurisdictions with respect to its application and enforcement. There's really two buckets when it comes to application of force majeure. There's two buckets of contracts we're really thinking about. One is contracts executed prior to COVID-19, whether that means prior to the first report of COVID-19, prior to it first hitting the United States, prior to the first declaration of it being a pandemic by the WHO, or the recognizing of it being a public health issue by a state, and then any contracts executed during or after the COVID-19 pandemic. So basic elements of force majeure. Bottom line is force majeure analysis is very fact specific. Start off, one, very simply, does your contract have a force majeure clause in it? Surprisingly enough, a lot of contracts don't. And so that brings in a whole other set of considerations. But along with, does your contract have a force majeure clause, what is the governing law of your contract? Because that is going to determine very much how that provision is interpreted. What events are specifically listed in the clause as qualifying for force majeure events? And I'll get into that in a little bit more detail. Does the event qualify as a force majeure under the contract? Is the risk of non-performance foreseeable and able to be mitigated? The main word in there right now being foreseeable. Who determines whether it's foreseeable? When is it determined as to whether it was foreseeable? Is performance truly impossible or impracticable? In other words, is there a causal link between the force majeure and the failure to be able to perform under the contract? Is it really truly impossible for you to fulfill the contract, or is it commercially impracticable? Is it financially impracticable? Different jurisdictions treat that very differently. What are the obligations of the parties? Does the provision provide indefinite excuse from performance? Is it a limited time performance? Are there express duties to mitigate in addition to any mitigation obligations that arise as a matter of law and interpretation of the contract? And then what are the remedies? Are there express remedies in the contract? We'll go into these in more detail excuse me, later, and Mark is going to really dive into contract remedies at law. But what are those remedies? How do you address the situation? So first and foremost, first question, does the event qualify as a force majeure? I think if we've seen one force majeure provision, we've probably seen 100 of them, and they can vary widely. But for the current circumstances, we all start looking for very specific language: pandemics, epidemics, disease outbreaks, public health crisis, government orders and acts, civil emergencies, even some, depending on the jurisdiction and depending on the scope of the contract, even more related to getting as specific as saying Ebola outbreaks and other particular diseases. Then you have your more general descriptions. Acts of God, a very standard, I use the word standard loosely here, a very standard piece of language from a force majeure clause, and then catch-all or boilerplate language of beyond a reasonable control of a party. When you're looking at these, go back one second, Alice. When you're looking at these events in the force majeure clauses, the one piece right now, and one of the main pieces of questions that we're getting is, how much can I rely on catch-all phrases, beyond a reasonable doubt, or any other event that was beyond the control of the party? Generally speaking, most courts do not put a lot of weight on catch-all phrases, particularly if you have a large enumerated list of events in the clause that says, all right, here's what the parties are agreeing are force majeure events, and there's a big list. The catch-all phrases right now are not something that I would say you can hang your hat on as making a force majeure clause definitively enforceable for COVID. Go ahead, Alice. So just as much as a force majeure clause defines what does qualify as a force majeure, there is also a world of items that do not qualify for force majeure, and for most jurisdictions are pretty consistent that these items they won't detain or defer off obligations of the parties under an agreement. So difficult market conditions, whatever that may mean, large room for interpretation. Could be economic conditions, could be performance conditions. Pure financial difficulty in performance is generally not considered to make a contract and the ability to perform impossible or commercially impracticable. This is a lot of the times the reason why you'll see carve-outs in a force majeure clause that say obligations to pay are not forgiven due to a force majeure event. And then events or circumstances that could have been anticipated or for which risk was assumed. This goes to the question of, was it reasonably foreseeable? Did you know, could you have planned for, could you mitigate the obligations based on the set of circumstances? And then one other bullet I should have included, any express exceptions to the force majeure clause. So are there any items that the parties have agreed to in the contract, in the clause, that these particular items will not be considered force majeure? Which is one of the big questions we're getting right now. So working through the elements, is COVID-19 a force majeure event that excuses performance? So first question, does COVID-19 fall within the force majeure clause? Does the clause specifically enumerate pandemics, epidemics, public health crisis? Does it specifically say COVID? Most likely right now, for any contract entered into prior to probably last month, it's not going to have COVID in there. And very likely it's not going to say a pandemic or epidemic. So then you're relying on acts of God, you're relying on outbreaks, diseases, and the like. Were the events unforeseeable and beyond the control of the party? So one of the arguments and one of the questions we're getting right now is, was COVID foreseeable? We had news of COVID outbreaks back in the fall. We had it in December. We had it in January. We had it in February. Does that make it foreseeable to the parties under the contract? Have the events caused the performance to be impossible or impracticable in some states? Again, the causal link. Is the occurrence of COVID itself the cause of the non-performance, or is a government order in response to COVID the cause of the non-performance? Is it a state order? Is it a federal government order? Is it a city order, mayor versus governor versus presidential, et cetera? And has the party claiming force majeure taken reasonable steps to mitigate? Is it possible to mitigate? Can the parties in the contract find an alternate route to accomplish what they need to despite COVID? In a lot of cases, the answer to that really, truly, simply is no. Under the scope of the contract, there is no possible way to perform. We're seeing this a lot, particularly in the hospitality industry. When events are canceled, catering companies have contracts canceled, planning companies are having their contracts canceled, et cetera. The domino effect is very much apparent. So remedies in the event of force majeure. Does the contract provide for remedies? Temporary excuse for delays in performance or non-performance. Is it expressly allowed? Is it time barred, time capped? And what happens if it is time capped? What happens when you get to the end of the time cap? Is it a termination right? Is it a right to cover? So can you go out and find an alternate vendor to perform if that's possible? And if you do, who covers the costs? If it's a termination right, is it termination with or without refund? Do you waive any remedies at law by terminating the contract or exercising a right to cover. All of these are items that, when looking at the force majeure clause, you need to analyze through as in order to figure out what is the best path forward to address the situation. If the contract doesn't address the remedies, you're not completely out of luck, I guess is one way of saying it. There are common law remedies available, and that's where I'm going to let Mark take over and walk you through what those are.
Thanks, Geof. This is Mark VanderBroek, and I'm a partner from the Atlanta office of Nelson Mullins. And I'm going to pick up the discussion here where Geof left off with force majeure and address the question of what happens if your contract either does not contain a force majeure clause, or if the force majeure clause doesn't apply to excuse performance in a particular situation. In that situation, in many states, you're still able to consider a variety of common law defenses that might apply to excuse contractual performance. And the main three that we're going to cover here are these ones listed: impossibility, commercial impracticability, and frustration of purpose. I'm going to provide an overview of each of those and how they might apply in this current situation with COVID-19 and related government pronouncements. And then I'm also going to spend a minute or two talking about commercial lease considerations, because we're seeing a wave of tenants seeking advice on this and providing notices to their landlords that they're going to be unable to make rent payments in April and going forward, particularly in the retail and restaurant space, but also in others. And of course, we're advising landlord clients on these issues too. Parties, then I'll also address parties' duties and remedies in the event the performance is excused, because it's important to consider that before you pull the trigger on a force majeure, is what is that going to do to the parties' rights and obligations going forward. Next slide, yep. So these other common law defenses, like force majeure, are going to be very fact-specific as to when they apply, and that will vary to some extent by state. And I'm going to be addressing these doctrines under U.S. law. If your contract is an international contract or calls for foreign law, they'll have similar concepts that might apply here as a defense, but I'm going to focus on U.S. law today. So the first defense is impossibility of performance, and this will potentially excuse performance if performance becomes objectively impossible because of an unforeseeable event. And traditionally, the law has truly required objective impossibility, as far as instead of just being very difficult to perform or being subjectively impossible for a particular party to perform. And the classic situations are these two that are listed on the slides: physical impossibility to perform because of destruction of the subject matter of a contract or the death of a party, and then legal impossibility due to a government law or order or declaration that has made something illegal or impossible to be performed. And of course, this latter group of legal impossibility is one area where we're starting to see argued with COVID-19 and the related government pronouncements to close down business and shelter at home and that sort of thing. But again, like in the force majeure situation, mere financial difficulty in performing or extreme market conditions is not enough to amount to impossibility. Next. A variation of impossibility that's been adopted in many states is commercial impracticability as a defense. And in fact, under the restatement of contracts mentioned here, the restatement actually substitutes impracticability in place of impossibility as a defense. And some states have followed that. Other states will still look at impracticability in addition to an impossibility defense. Also, the UCC, addressing sale of goods, has a provision that addresses commercial impracticability that sellers can potentially invoke. But the general concept of commercial impracticability is that a party's performance can be excused if first performance is made impracticable. And what that means basically is it's impossibility plus. If it would be impossible to be performed because of legal impossibility or otherwise, that will qualify. But impracticable gives you a little more leeway to argue that extreme difficulty or extreme expensiveness to perform may be enough. if the performance is made impracticable without the party's fault, and by the occurrence of an event, the non-occurrence of which was a basic assumption on which the contract was made. What that basically means is that an event happened that was so extraordinary and unforeseen that it makes performance under the contract vitally different from what was reasonably expected, so as to essentially alter the essential nature of the performance. And I think with COVID-19 and the disruptions and impact it's had with the related government pronouncements across the country and the world, I think there's going to be certainly legitimate arguments in many cases that this is that we do have an event that could potentially excuse performance under commercial impracticability in the right situation and under the right contract. The last bullet point is, unless circumstances indicate to the contrary, again, if the contract puts the risk of non-performance on one party or a particular event on one party, then that will override. A third variation of this common law defense is frustration of purpose, which will potentially excuse a party's performance if the principal purpose of the contract is substantially frustrated. That also has to be without the party's fault, and again, by the occurrence of an event, the non-occurrence of which was a basic assumption on which a contract was made. So this is similar to impracticability, but the difference is that with frustration of purpose, there's not an actual physical impediment or other impediment to performing. It's just that the fundamental purpose of the contract has been frustrated by an unexpected, unforeseeable event. And the classic example that for those of us that are lawyers we learned about in law school is someone that has rented a room and paid good money to do that to view a big parade that was going down the street. And then the parade ended up being canceled because or rerouted to a different route. In that event, the tenant could still pay rent and use the room, but the fundamental purpose for the use is gone. And the restatement has identified that as a potential frustration of purpose situation. And I think that's a situation you're going to see tenants arguing in connection with leases as well. The frustration of purpose must be near total and very severe, so that, again, without it, the transaction would make little sense. Next. I did want to spend a minute or two talking about commercial leases because this is the one area in which we are probably seeing the most activity and most clients seeking advice in connection with these areas, although we're seeing them in connection with a lot of different contracts too, supply contracts, manufacturing contracts, contracts relating to events, hospitality, and travel. But we're seeing a lot of tenants who are providing notices to landlords that they're not going to be able to pay their rent in April or in the coming months until these government shutdown orders end. And you know, that may in fact, because of the virus or because of government orders, could definitely potentially be an event of force majeure or a event, the non-occurrence of which was a basic assumption to potentially excuse performance. But one problem that tenants may have in these situations is that many commercial leases have force majeure clauses, but many of those clauses do not excuse the tenant's payment obligations, even in the event of a force majeure event. So landlords will argue that intent controls. Tenants are going to be expected to argue that the performance could still be impracticable or frustrated, have a frustrated purpose under the common law doctrines. Again, the landlords will argue that the intent of the contract ought to control. There should be no excuse of payment. And then the tenants may come back and argue some of these other clauses as showing the intent of the contract as far as permitted and required uses of the premises that they're not able to make while the businesses are shut down, quiet enjoyment rights, and that sort of thing. There's been some discussion of constructive eviction or temporary takings in these situations, but there would be a number of hurdles in connection with those for tenants to get over too. The bottom line with respect to leases is there's going to be a number of arguments that both tenants and landlords can make. And again, how that comes out will depend on a particular lease and a particular factual situation, and possibly with differences state by state. Next. Now I want to kind of change gears here and address what happens if force majeure or the other defenses do in fact apply to excuse one party's performance under a contract. what are the parties' rights and duties and remedies then going forward? And as Geof mentioned, sometimes the contracts in force majeure clause will address what happens in that situation, and in that event, what's discussed in the contract should control. But I've seen a number of force majeure remedies that provide events that will excuse performance, but then they don't provide any other rights or remedies beyond the initial excuse. And what happens? And in that event, you're going to fall under these common law principles that I'm going to talk about. And again, these are also going to be dependent on particular facts and circumstances as to how these play out and get applied in particular situations. But here's some of the things to consider. First, if the excusable event is a temporary event, like we all certainly hope and expect COVID-19 and the related government pronouncements to be, then the duty to perform is going to be generally suspended for some period of time, but not discharged. But keep in mind, for in representing clients or in providing notices of force majeure or excused performance, if you want to make sure that the other party knows that you're only suspending temporarily and not trying to discharge the contract. So think about that in connection with your notice provisions that get sent out. Second, if only part of the performance is excused and you're still able to render the other part, you should do that. A party should do that in order to try to mitigate if it can still substantially perform. So if you're a manufacturer and supplying parts to other companies, if you can't get supplies from China or somewhere to manufacture at full capacity, but you can do partial, send out what you can. Third, what happens to the other party's obligations under the contract once performance is excused? That's going to be very fact specific probably, but at a minimum, the other party's performance obligations is going to be suspended during the suspension of the first party's performance. In some situations, they may end up being discharged. If a supplier of widgets is unable to supply for a period of time, obviously the buyer doesn't have to pay. If they supply later on, he can resume payment. Keep in mind and think about in analyzing rights, regardless of which side you're on, could the other party terminate the agreement in response to a force majeure notice or other notice of excuse of performance? You have to consider the risks involved in sending a notice excusing performance. Sometimes you may not have any choice. But we're seeing, for example, in the construction contract situation where contractors have given notice of force majeure and delays in performance because they're unable to get supplies or otherwise, and we see them in some situations, owners and developers seeing what the landscape looks like economically and exercising rights under other provisions of the contract to terminate a contract for convenience or other grounds. So think about what the other party could do in this situation, and part of what you can do is craft your notice letters or response letters in a way to perhaps try to craft where you would like your side of the bargain to go. Finally, restitution and other equitable remedies might come into play to protect parties' rights too, particularly on the monetary side. If performance is excused and money payments are excused, at some point in time, those will have to be made up. The money payments will have to be made. And when and how much and under what circumstances is something that is going to depend on the facts and obviously can be negotiated. Next. All right, my final slide here are just kind of reiterating some of the practical issues to consider. We've talked about some of these already in analyzing either force majeure or related defenses. Again, they'll be fact specific, but again, review and analyze your force majeure clause and applicable law. Yes, COVID-19 and resulting government pronouncements often will be covered, probably in many force majeure clauses. And in many cases, the event may be unforeseeable and outside the party's control, although not necessarily always, particularly if the contract was just entered into in the last couple of months. A big issue, as Geof mentioned, has the event caused the performance to be impossible or impracticable? That'll be a very fact-specific question. Have steps been taken to mitigate the impact? Alternative supply, remote working, other things. Consider alternative defenses if no force majeure provides. Do be conscious of providing timely and adequate notice to the parties, to the other side. It doesn't necessarily need to be long notice right away. It can be short notice, and may depend strategically on how you want to approach things, either more or less detail. But important to comply with any contractual notice provisions, or even if the contract doesn't apply, you're operating under the common law, let the other party know the basis of what you're doing. And same thing in response. Of course, there'll be arguments made back. Finally, consider the party's duties and remedies upon excused performance, and consider that in advance of when you send your first notice and what the possibilities might be. And finally, on negotiating resolution, as you can tell from Geof and my presentation, there's a lot of gray areas in the law here because the factual details of particular contracts and particular circumstances are going to determine how these principles are applied. But there's no question that we're going through an extraordinary, unexpected event, having a national or worldwide scale that we frankly haven't seen in our lifetime, with a substantial disruption of businesses, and at least some of whom are going to have an impaired ability to perform or pay going forward. So in some situations, the smartest thing will be to negotiate things out best you can. Other times, we're sure we'll be seeing some litigation, too, that'll help reshape force majeure and this other law going forward. Thank you, and with that, I'm going to turn it back over to Geof to cover one more subject on drafting force majeure clauses.
Sure. Thanks, Mark. So really tying into the practical considerations Mark was just going over, really kind of the takeaway in thinking on contracts you're currently working on, thinking of contracts you're going to be working on in the future, kind of either during COVID-19 or after it's gone. I think really roll through the set of questions. What's the scope and nature of the contract? Taking into consideration what would a force majeure clause mean, force majeure event mean for this contract? How's that going to affect it? Frankly, which side of the table are you on in the contract? If a force majeure happens, how can it affect you? How could it affect the other side of the table? And what do you want the outcome to be? I think legitimately there is a question of, is it better to leave out a force majeure clause in the contract? Given the circumstances, scope, and nature, is it better to leave it to contract law interpretation? Do you want a broader or a more narrow clause? More explicit items for force majeure, more carve-outs from force majeure, or do you want a much more narrower written clause? And then what remedies do you want? As Mark was talking about, there are remedies at law, and there are remedies in the contract. Is it going to be better to put them in the contract and have the parties agree to it, or would you rather rely on possibly what the remedies at law are in the event something was to come up? I think in the grand scheme of things, again, look at everything as a whole as you're kind of analyzing through the contracts and looking at the facts. But we certainly appreciate everybody taking the time this afternoon. I think, Alice, is there one more slide? Mark, do you want to touch on these real quick? I may have lost Mark. We just want to hit these.
Sorry, Geof, I was on mute.
Oh, yeah. No worries.
Yeah, just very quickly, we're also getting a lot of questions from clients in addition to the force majeure and related issues of whether their businesses are an essential business that can not be under the shelter-at-home orders, and also addressing business interruption insurance and when that is available and the coverage issues relating to that. We don't have time to cover that in the seminar today, but we have lawyers who are advising clients on this and able to advise you or your clients on these issues as well going forward. Thank you, and with that, I'm going to turn it over to, I think, either Mitch or Ann to get us going on some employment-related issues.
Good afternoon. This is Mitch Boyarsky. I am a partner in the employment group in Nelson Mullins' New York office. Ann and I are going to cover the employee implications of the Family First Act, and particularly leave, which I'll cover, and Ann is going to touch on some of the business implications. I'm going to just start us off, if we can go to the next slide, to introduce the legislation. It is effective April 1. There was a provision in the law that said it's effective no later than April 2nd. Please keep in mind it is April 1, and that's definitive. The law provides for paid leave to employees of a company when the company remains open, but the employee cannot work due to one of the qualifying reasons listed in the statute. I will touch on those. If an employee receives pay, the pay is made by the employer. Later, an employer can file for a refundable tax credit. Again, we'll touch on that shortly. More information is becoming available as we speak, quite frankly. The Department of Labor just issued FAQs on the application and the interpretation of the Emergency Family Medical Leave Act. Last night, the DOL just issued the notices to be posted in the workplace to the extent that they can be posted physically, and I'll mention that in a second. And then the EEOC has issued guidance for employers while they are operating, how to communicate with employees about the virus, medical issues, and other considerations such as prohibiting discrimination and protection of employee rights. I would suggest that if an employee is not in the office, then for the notices, they should be emailed. And even if an employee is on a leave of absence or furloughed, I would suggest that if the employee has access to electronic communications, you provide that notice as well in the event that the employee could later return to work. We can go to the next slide. Now, I know we mentioned the resources page from our website. I am including it here just to give it to you again and show some of the resources available to you. As I mentioned before about the notice postings, that is happening in real time. So actually, our alert about those notices just went up. And I would suggest that if you want any of these resources that I just mentioned, the FAQs from the Department of Labor, the guidance from the EEOC, the notices, although we do include an URL later on, with those, see our website. It is all there. It's very user-friendly, as you can see. You just click on the link, you'll get our alerts, and you will also get connected to those government-issued guidance and notices. Next, please. Next. So we're going to talk about the emergency FMLA, and that is really an expansion of the traditional FMLA. I'm going to try to simplify this. It is really two parts, and to emphasize, we have really taken a lot of this information for these slides from our alerts. So if you go to our website, you will see these pretty much as you are viewing them on the slides, but I will go through those. First, the Act provides for job protected leave for up to 12 weeks, similar to the traditional FMLA. Let's talk about who's covered. It covers employers with less than 500 employees. An exemption exists for smaller employers, or small employers whose businesses would be jeopardized if they complied with the Act, so that they would not be able to continue as a going concern. They can be exempted. According to the DOL, and specifically the FAQs that just came out, that is a fact-intensive analysis. Employers should be prepared to document if they're claiming the exemption, but, and I'll emphasize this, but you don't need to send anything to the DOL. They're not asking for any submissions about that, at least for now. An employee must be employed for 30 days prior to the effective date, which is April 1st, to be eligible. Employees who are healthcare providers and emergency responders can be exempted by an employer. The definition of a healthcare provider, I would refer you to the regular FMLA and its regulations. As an example, a chiropractor or a pain management doctor is a healthcare provider. So when in doubt, check the FMLA regulations, because the emergency FMLA is an amendment, or just call your employment lawyer. The covered events are: 1, an employee is sick. Number 2, the employee is at home to care for a child under the age of 18, unable to attend school. or have child care services by a provider of child care services due to the virus. For one of these situations, the first 10 days is unpaid. After the employee can receive pay, the pay rate is 2/3 of the employee's regular base pay, up to $200 per day. If an employee has available vacation, sick, or PTO under a company policy, the employee can elect to use it. If the employee is entitled to a statutory benefit, such as the New York law, for the employers who are in New York, that went into effect on March 17th. The employee can use the paid statutory benefits first. There is a formula for part-timers to use a method to calculate the part-timer eligibility, which requires looking back over a 6-month period. Next, please. How much notice is required? Well, it's really however much is foreseeable in the eyes of the employee. At the end of the 12 weeks, the employee is entitled to reinstatement. There is an exception for an employee who is on leave due to a public emergency or the employee's job no longer exists. This is the same standard as the FMLA. If an employee were considering taking, an employer were considered to take this position or your argument, I would suggest that you consult with counsel because you may be required at some point to defend that. Next, please. The Act does provide for the same coverage for employers and for the exemptions for when an employee is taking a leave due to an emergency. If the employee is unable to work or telecommute, then the employee can get the paid leave for one of these reasons. At the end, the employee is entitled to the job restoration rights, and note that if an employee is affected by a reduction or because of a public health emergency such that the position no longer exists, the employee is not entitled to job restoration. Next slide. So we're going to talk about the emergency version. We talked about the paid sick leave. Again, the same criteria to cover. It applies to an employer with fewer than 500 employees. It does apply to government agencies as well, which I should have mentioned is for the emergency, is the first form for the paid. And then if an employer has less than 50 employees, again, they can claim the exemption. There's exceptions for healthcare providers and emergency responders, and this is something that is effective immediately. Next slide. Okay, so here's the reasons why an employee could take the emergency paid sick leave. Now we've listed them as 1 to 6. In the next slide, I'm going to go back and reference these circumstances for which an employee gets different versions of the pay. So you need to be careful about which pay applies to which reason. But for the most part, if an employee is unable to work or telework, however, the employer is open for business, the employee can take the emergency leave because of a government mandate to isolate or self-quarantine. We call them the stay-at-home orders. The employee was advised by a healthcare provider to self-quarantine. The employee is experiencing the symptoms or seeking medical diagnosis. The employee is caring for an individual. And that's an important term because the traditional FMLA applies to an employee taking care of a family member with a serious health condition. And now this is expanded beyond that to an individual, where the individual is subject to a quarantine or an isolation order. Also because the employee is caring for a son or daughter whose school is closed, or because child care facility or child care provider is unavailable. And finally, because the employee is experiencing the symptoms of the virus as published by HHS. Next slide, please. For this emergency paid sick leave, the leave is immediate up to 80 hours or 10 days for the payment for sickness. Part-timers, there is a formula to use, and that formula is based upon the number of hours that the employee would have worked over the prior 2-week period. For the leave for sickness, and if we can go back to the prior slide, for circumstances 1 to 3, it is paid at the rate of $500 a day max for a total of $5,110. For sickness leave for the reasons numbers 4 to 6, the pay is 2/3 of the employee's regular rate, up to $200 a day for a total of $2,000, and a combination of the sick leave for emergency and paid sick for the emergency FMLA circumstances would be for $200 a day max, or $12,000 for the entire emergency leave period. We can just go back to the following slide. Then remember, there's no 10-day waiting period if someone is sick. The employee also has the option of taking any one of the available leaves under the company policy or statutory leave if they want in conjunction, but an employer cannot mandate that the employee take any one of those leaves before the emergency FMLA if it is for one of the reasons that triggers immediate leave, which is primarily sickness. And finally, there's no carryover. So if we can go to the next slide, I'll talk about the postings. Here's the URLs for the postings. They're both for federal or government employers, I should say. They are for private employers, and the DOL's FAQs regarding the posters and how to post them. So those posters, as I mentioned, need to be up in your facilities by April 1. If you cannot post them, then you should email them or put them on a shared drive or intranet where employees can see them, and then make employees aware of them. I'll remind you that there's prohibitions against discrimination and harassment for an employee taking emergency family medical leave. And if an employee were to file a complaint or asks to seek the leave and is denied, or the employee would claim that there's an issue about being able to receive the leave easily, that could be a circumstances that gives rise to a discrimination or interference claim. So we need to be careful about authorizing leave. I would suggest, when in doubt, it's appropriate to give the employee the benefit of the doubt. Thank you. So we can advance to the next slide.
Thanks, Mitch. And I think that just two key clarifying points on what Mitch was just talking about is the 30 days that an employee has to be employed in order to qualify for the emergency family medical leave. That's going to get measured from the time they're first trying to take that leave. So, that's sort of going to be a running, even those that you hire going forward will eventually become eligible for that leave if they're with you for 30 days or more. And if they worked as a temporary employee prior to becoming full-time with you, you will have to count that temporary time. So work with your consultants or attorneys to make sure that you're properly crediting that service. And then also, on an added note, the exceptions for healthcare providers that Mitch talked about, many of us in our minds have an idea of what a healthcare provider is. But the one thing we can tell you in the last few days of working with these laws is that the definition of healthcare provider is much narrower than you expect. And so if you are assuming that all of the people in your business are automatically qualifying as healthcare providers because, for example, maybe you are a diagnostic imaging center or a physician's office, don't assume. Make sure that you talk with your advisors, because there are some tricky nuances to what that definition is. Okay, moving forward to employer health plan mandates. So everyone who has an employer-sponsored health plan, whether you are fully insured or self-insured, has to comply with these requirements. And the requirements provide that you have to provide for no cost-sharing requirements. That means no copays, nothing counting towards the out-of-office or out-of-pocket maximums, no co-insurance. You have to cover the full cost of diagnostic testing for COVID-19. And you also have to pay for the office visit, urgent care visit, or emergency room visit that leads up to that testing. Now, that doesn't mean if someone went in for a different purpose and they're getting some other treatment during that visit that you have to cover that with no copays or co-insurance. It's the portion that led up to and is coded in connection with the COVID-19 testing that you're going to have to make sure you cover. So for those of you that are fully insured, that's going to automatically go into place within your insurance policy. But for those of you who are self-insured, that actually likely does require you to amend your self-insured health plan. And remember, as a self-insured employer, if this applies to you, you're going to want to make sure anytime you amend your health plan that you talk and notify your stop-loss insurer, because unless they've been notified of an amendment going into effect, they may not agree to cover those additional costs. So just things to put on your checklist to make sure that you don't forget. You also should provide notice to your employees, whether you are fully insured or self-insured, that this is a change that's happening to your plan and that these are available. And for those of you who have adopted it has become so popular today, the high deductible health plan, actually go ahead and go to the next slide. Even if you sponsor a high deductible health plan, this still applies to you, and they've come out and said it's not going to jeopardize the requirements that would normally apply to high deductible health plans and health savings accounts. So make sure on this testing, so whether you're fully insured, self-insured, even if you're grandfathered, I know there aren't many of you anymore, but for ACA purposes, some people still are grandfathered. It applies to everyone. So this is immediate. This is not one of those where we're waiting until April 1st or 2nd to take effect. So it will continue until the end of the national emergency period. We don't know when that will be, but stay tuned for further guidance. Next slide. Now, Mitch talked about all of these paid sick leave and paid FMLA costs that are looming out there, and I know that scares a lot of employers. But to the government's credit, they did, as part of the act, they did implement tax credits that you will be able to take advantage of. These tax credits are available to you to cover 100% of the cost of the paid sick leave and the paid FMLA leave that you are going to have to provide. And not only that, but they also will cover the health plan coverage that you provide while people are on those paid sick leaves and paid FMLA leaves. The way that's going to work is you will be able to take a credit for what you pay beginning April 1st. Each time that you go to process your payroll and where you would normally cut your payroll checks and send your tax deposits into the federal government, instead, you will be able to calculate the wage costs that you're spending for the paid sick and FMLA leave and the health coverage cost. Note that if you have different payroll providers and HRIS systems, you're going to have to find some way, even manually, to try to make sure you get that information over to your payroll provider timely so that they can add all that up together and offset the taxes that they're depositing with the federal government. So the idea would be, let's say, you owe $10,000 on a normal payroll run, but you've paid $10,000 in taxes off your normal payroll run, and you've paid $5,000 towards paid sick leave and paid FMLA. Well, you would go to process your payroll, and you would take the $10,000 that you normally would have forwarded to the federal government for, and we're talking for federal income tax withholding or for Social Security and Medicare taxes. You can take that money and just keep it and hold it and use it to fund the wages that you are paying under the paid sick and paid FMLA leave. So it really does cover you for that whole cost to the extent, and there are going to be some of you that are in this circumstance, to the extent that the amount you end up paying out actually ends up being more than you owe in taxes. The federal government is saying that it will actually have a process, an expedited process, where you can apply for a refund of that money, and they will try to get that to you as soon as possible, and in no event more than 2 weeks after the request. Now, we don't know exactly how fast that will be, but it's certainly they're trying to work with people and make sure that you have the funds. Next slide. So even though you do this offset each pay period, the tax credits will get formally reconciled when you file your quarterly Form 941. As we said, guidance is coming out, daily, if not hourly, and we will try and keep everyone posted as we get more guidance on how you, for example, apply for this expedited advance. I'm sure there will be some steps or schedules that will go with the Form 941 to reconcile these amounts, but we just don't have that at this point. Next slide. So when we talk about the tax credits, who's going to be eligible for them? I mean, if you are one of these people, one of these entities that has to comply with paid sick or paid FMLA, you're going to be eligible. Government employers, though, are not eligible for the credits. Interestingly enough, and this may impact people you know or family members, self-employed individuals, both independent contractors, partners in a partnership, S corporation shareholders, all self-employed individuals are also going to have a right to claim credits for some of these paid leave mandates and to take advantage, actually, of these paid leave mandates. So that's all built into the law and kind of outside the scope of this presentation, but we just wanted to make sure that you were aware that those were something that's out there. Next slide. So talking about a few just miscellaneous points that we want to make sure everyone is aware of. All of these paid leave mandates are currently set to sunset on December 31st. So that could get extended if these conditions, last longer than everyone expected. And there is a good faith sort of excuse for those of you who may be concerned that, that you won't be able to come into compliance fast enough. The Department of Labor has announced that it will be issuing a temporary non-enforcement policy that will allow you 30 days to come into compliance with the Act. Now, that does not mean that you should spend 30 days coming into compliance. It just means that, if unforeseeable circumstances delay you, you may have some defense. Next slide. And then also note, those of you who are unionized or have union employees and are subject to a collective bargaining agreement, there are some specific provisions on how you can make contributions to a multi-employer plan that will be deemed to satisfy these rules. If that applies to you, reach out to your labor counsel and make sure that you talk in detail with them. Next slide. Okay, the latest breaking news. We're going to talk about the CARES Act for just 2 minutes here, and then we'll move on to our next group. The CARES Act is not yet law, but what you need to know is that the CARES Act has been passed by the Senate yesterday. The House is set to review it tomorrow, and the President has indicated that he will sign it when it is approved. What is really important here is for those of you who are trying to decide what you're going to do with your employees, whether you're furloughing, laying them off, keeping them, and making sure that you're going to be able to comply with paid sick and paid FMLA. The CARES Act has specific provisions that are going to give small businesses, which currently is defined as 500 or fewer employees and is tied to some SBA qualification requirements. But that provides that you will be able to apply for loans that will help your business. The amount of the loan is generally 2.5 times your payroll during the prior 12-month period, or I think it caps out at, if I'm not mistaken, $10 million if greater. This is really important for you to note because there are certain conditions that apply to your receipt of money under the CARES Act, and if some of those conditions include your duty to retain employees, meaning not lay off or furlough, or to the extent you have laid off or furloughed, to bring them back as required by the Act. We're waiting for the final language in the Act, so you really can't take action now in reliance on it, but it's certainly something that you want to keep in mind as you're making your employee decisions. And I think, Mitch, if you're still on, you were going to touch on the unemployment insurance for a second before we move to the next group.
Thanks, Ann. So we've listed the potential benefits under the plan per individual. As we noted, there is maximums. There's the thresholds, at least that we believe would go into effect for individuals and couples who file jointly. And there's going to be a phase out for highly compensated income individuals. Under the proposed law, workers would receive, in essence, unemployment insurance benefits, and I'll call it unemployment insurance benefits on steroids, which is $600 per week, and that's up to a 4-month period of time. There's benefits. These benefits, I should say, would be on top of state benefits. And just to note that many states are passing executive orders that change the eligibility criteria for unemployment as we speak. I just heard that the Georgia governor issued an order about benefits eligibility. So you really need to be mindful when, as Ann said, considering these kinds of decisions about furloughs, reductions in force or otherwise, such as a reduction in employee hours, what, if any, impact that's going to have on benefits eligibility. But these benefits under the Federal CARES Act would layer on top of those state benefits, and there will be caps. It also would provide to one-time payments to individuals up to $1,200 or possibly more. But that, again, those details are being hashed out. So right now, this is an over 800-page law that really came out yesterday. We've been analyzing it. We will continue to analyze it and communicate more information about it. So please pay attention to our resources page for more information. And of course, if and when the final rules come out, which we are hoping will be relatively soon, reach out to your counsel to figure out what's the best strategy in light of the statute. Can you just turn to the next slide, please? So as Ann had said before, there's some eligibility issues. In addition to typical unemployment insurance benefits, the proposed statute would include independent contractors and self-employed, and also reiterate that there would be some incentives to maintain workers or perhaps disincentives to terminate workers, at least permanently, that could frustrate an employer's ability to obtain financing or loan forgiveness for small businesses. So that wraps up our section. I will pass on the baton.
Good afternoon. Welcome to the third session, which is navigating the new financial and business frontier. approaching the crisis from the business, borrower, and creditor lender landscapes. Because this is the last of our 3 presentations, we want to take a bit of a different approach. So our presentation is going to be in the form of a skit. And before we get to the skit, I wanted to give you our last code word for the afternoon, which is Nelson, N-E-L-S-O-N. I'm Gary Freedman. I'm a partner here at Nelson Mullins. I'm one of the vice chairs of the Bankruptcy and Financial Restructuring Practice Group, and I'm located in Miami, Florida. Shane?
Thanks, Gary. This is Shane Ramsey. I'm a partner, and along with Gary, one of the vice chairs of the Bankruptcy and Financial Restructuring Practice Group, and I'm based in Nashville, Tennessee.
So the economic topics that we want to talk to you about in the limited amount of time we have are fairly broad and far-ranging, but there's an overriding concept that we want to emphasize today, which is what we are calling CC Rider. And what CC Rider stands for is communication is in crisis rider. In other words, communication should be added to all of your agreements and business arrangements as we get through this crisis. This is exactly what is required based on the unprecedented fluidity in our economy based on the ongoing fallout from COVID-19. No one knows exactly when the virus will end or what the long-range economic effects will be, but we are already seeing the effects throughout all aspects of our economy, including the most at-risk industries, gaming and leisure, transportation, energy, and retail, among others. The issues we are facing are serious, but please forgive us if we added, or at least attempted to add, a bit of levity in our skit. Shane, can you explain to our audience your business, please?
Yeah, so I'm going to be moonlighting today as an actor, playing a commercial landlord of a building in Nashville called Market Madness, which is a building that consists of 6 retail stores. We have a commercial mortgage with First Bank of Honky Tonk, which Gary will be playing the banker for. The 6 stores are Popeye's Gym, Beatrice's Bistro and Wine Bar, Vinny's New York Style Pizzeria, Massage Trendy, and Greg's Gunnery. And all are shut down under the non-essential business shutdown order, except for Vinny's Pizza Delivery and Greg's Gunnery, because we all know that pizza and guns are essential under Tennessee law.
Can we move to slide 42, please? Yeah, and I'm going to be playing the role of a senior workout specialist for Honky Tonk Bank, dealing with the financial issues generated by COVID-19. Next slide, please, 43.
So, hey, Mr. Banker, thanks for meeting with me today. I've heard that it's very important to proactively communicate with your lender during the health and economic crisis, which COVID-19 has created, and that's why I'm here to meet with you today. And as you know, the bank has a first mortgage on my property. My tenants there are getting squeezed by this crisis, and they've all told me that they're going to stop paying rent as of April 1st. Most, except for Vinny's Pizzeria, they're paying partial rent, and Greg's Gunnery is just killing it right now during the crisis, selling guns. Most of them, other than Vinny's and Greg's, won't be able to pay rent for the near future, and they've asked for rent abatement. They have, based on some a concession I asked for was, they give me interest on the rent abatement payments, which they've agreed to, and I appreciate that. And I'd love to work with them, but I've got these mortgage payments with the bank and these loan covenants with you guys, and I just need, I need some relief. And I'm not really sure what's going to happen when the economy's going to turn around, and what can you do to help me out here?
Well, Mr. Landlord, First State Bank of Honky Tonk subscribes to the concept of CC Rider. That's full and forthcoming communication during this crisis. But there's just one thing we need to do before we can discuss your financial dilemma. You will need to sign a pre-negotiation workout agreement.
Yeah, what's a pre-negotiation workout agreement?
Mr. Landlord, it's just an agreement that says that nothing during our discussions are binding on the bank unless and until they are put in writing and signed by the bank. This is a condition for any conversation that we have about your financial dilemma.
Yeah, sure, no problem. But I'm looking at this and I can sign it. But what do all these other words mean?
Oh, those other words, it's nothing major, just a couple of minor details. Like you admit that the debt is both in monetary and non-monetary default. You admit that under the circumstances of COVID-19 that the bank believes, and you agree that there's a material adverse change under your loan documents, and that has been triggered. You admit the amount of the debt, that you have absolutely no defenses to the bank's legal rights to immediately foreclose on its mortgage. And in fact, if we can't work out an agreement, you have consented to the immediate entry of a final judgment of foreclosure. And if you happen to file for bankruptcy, or even if you're thinking about it, you admit that the bank is undersecured for purposes of immediate entitlement to stay relief under Section 362 of the Bankruptcy Code. And conversely, the bank's oversecured for purposes of Section 506B of the Bankruptcy Code that would entitle the bank to interest and attorney's fees on its debt if you were to file for bankruptcy. Those are the minor provisions, among other things.
That's one heck of a CC writer there, Mr. Banker. I probably should talk to my attorney before I sign something like that. But I don't suspect with all the potential foreclosures out there and the depressed real estate market that your bank's really going to want to take back the property that Market Madness owns. So, for purposes of today's discussion, why don't we just, believe that I signed this rider?
Well, for purposes of today's discussion, and since we're giving this presentation, I guess we'll have to agree. But I have a quick question for you, Mr. Landlord. Does Market Madness or any of its tenants have business interruption insurance? I think some of these liquidity issues could be solved by interruption insurance. Market Madness would receive relief in the form of working capital, allowing it to pay its obligations as a going concern, including the debt service to the bank. From the bank's review of the loan documents, we weren't certain whether or not there's business interruption insurance. Could you let me know, please?
Yeah, I don't really believe in insurance.
Well, that's unfortunate. We'll know for the next time, won't we? And if it did, we would obviously want to make sure that the bank was listed as a lost payee on all of the insurance policies so that the bank would be entitled to receive directly all insurance proceeds. Now, our attorneys recommended that we go back, given the crisis, and go through all of our loan files and make sure everything is in order, including perfection of our mortgage liens and security interests. In fact, we started that process and we discovered that our UCC financing statement on Market Madness to perfect the bank's security interest in your personal property was mistakenly filed in Tennessee, when Market Madness is in fact a Delaware corporation. So last week we went ahead and filed our UCC in Delaware.
I was talking to one of my attorneys, and it's interesting you brought that up. They had mentioned that, if this financial crisis really sticks it to me, I can file for bankruptcy, and anyone who perfects a lien within 90 days before the bankruptcy filing, that could be avoided as a preferential transfer. That might be a bargaining chip I have with you.
Well, Mr. Landlord, I hope you remember that you also signed a personal guarantee when we did this loan for you a year ago. So even if Market Madness files for bankruptcy and we're not made whole through the property, you'll be responsible for making up the difference. That is, if you'd be so kind to re-sign the guarantee agreement, because when we went back through the documents, we couldn't find a signed copy. Would you mind?
Yeah, maybe that's something we can talk about in respect to a potential forbearance agreement on these loan payments. But in the meantime, I've been doing some investigation regarding these government-sponsored debt relief programs. And the government set up a program to provide relief on individual home mortgages provided through Fannie Mae and Freddie Mac, and the FHA has implemented a 2-month eviction and foreclosure moratorium for single-family homeowners with FHA-insured mortgages. So that's going to halt mortgage foreclosures and stop other foreclosures from going forward. Mr. Banker, is there anything that requires you to give relief to a company like Market Madness?
Well, so far, I can't tell you that I've seen anything in that regard, but the process is fluid and programs are being announced on a daily basis in order to stimulate the economy and provide relief to smaller businesses that make up 50% of our economy. And in fact, just a day or so ago, the Senate passed something called the CARES Act to provide financially distressed consumers and small businesses greater access to bankruptcy relief, among other things. The legislative package, which passed Tuesday, passed 96-0, provides a $2 trillion economic stimulus for U.S. industries and citizens faced with challenges of the COVID-19 virus. The legislation now goes to the House, where it's anticipated to be approved on Friday and signed shortly by President Trump. I know it also provides some additional bankruptcy relief, but we can talk about that in a moment.
Yeah, well, my attorneys have advised me that I should provide notices of default to my tenants so that I can, preserve all my rights, while I'm still trying to work out payment arrangements with the bank, which is part of the reason I'm here. But, it was interesting. I was listening to a webinar earlier today, and Nelson Mullins really seems to be on top of this force majeure issue, which some of my tenants have been, bringing up to me. Geof Vickers and Mark VanderBroek had some really good advice on that. It seems like that might be the defense that some of my tenants raised to paying rent to me.
That's something that you should consult with your attorneys about. But just like you want to give notice of default to your tenants, you'll understand that as we try to work through your financial distress issues, that the bank is sending you a notice of default and acceleration of the debt just to preserve our rights should you decide to stick your toe into the bankruptcy pond. Now, one of the things we will need to discuss is the covenant and ratio requirements under your loan documents.
Yeah, I've consulted with a bankruptcy attorney, and she's told me a couple of things. And one, that's, my tenants, like I said, they might stop paying rent. They might seek bankruptcy protection to stop the eviction action. And I guess there was a new law passed and it went into effect in February called the Small Business Reorganization Act, which makes it easier for small businesses with $2.7 million or less in debt to restructure their business under the bankruptcy code. Unlike a traditional Chapter 11, what I've been told from my attorney is that, only the debtor can file a plan of reorganization to reorganize those debts. The debtor doesn't have to file what's called a disclosure statement, which outlines all of the risks associated with the Chapter 11 plan. That the plan can even impair every single creditor and still get approved, even if every creditor votes no for it. And that the absolute priority rule, which generally would prevent, the owner of the company from receiving a distribution in the bankruptcy, if other creditors are not paid absolutely in full, doesn't even apply. So, that seems like something that would be pretty attractive to small businesses right now. And I'm, worried that they might do that. And she also said that if, Honky Tonk Bank squeezes me too much, I should just, might want to consider filing for bankruptcy.
Well, I certainly don't want to give you legal advice, Mr. Landlord, but going back to the CARES Act, one of the things that it contains is the possibility of increasing the eligibility threshold for the small business cases under subchapter 15 from $2,725,000 all the way up to $7.5 million. So that's something that we ought to keep an eye on as well. But the last thing that the bank wants to do is push you into bankruptcy. But I assume your bankruptcy attorney also mentioned to you that if you were to file for bankruptcy, it would be what's known as a single asset real estate case, as defined under section 10151B of the Bankruptcy Code. Market Madness generates substantially all of its income from operating the single property and related activities. Well, what does that mean for you, Mr. Landlord? Well, it means that most likely you'd be required to commence contract interest payments to the bank and come up with a feasible reorganization plan all within 90 days. And she mentioned something about 362D3 of the Bankruptcy Code that controls those obligations. But, Mr. Landlord, we really don't want to talk about bankruptcy, do we? Let's keep talking about what we need to do to help out Market Madness through this financial crisis. As you may or may not know, breaches of covenants generally allow lenders to declare a default on their loan documents and demand early repayment of loans so that borrowers will not have access to their liquidity facilities. And you also know that these same type of covenants and ratios, they apply to asset-based lending and lines of credit too. So if you're looking for one of those, the same type of obligations will control. Mr. Landlord, did I cause you to pass out? Are you still there?
You did. Yeah, I am. That was a lot of stuff above my head. So it sounds like, borrowers such as me faced with prospective breaches should consider, taking steps on a timely basis to determine whether, they can or should draw on their existing available debt facilities or whether it'd be prudent to seek a waiver in advance. Is that right?
That sounds right, Mr. Landlord. And lenders also need to pay closer attention as to whether the conditions to borrowing have been satisfied. Moreover, lenders like Honky Tonk Bank should ensure that borrowers comply with their reporting requirements and notification requirements. These type of requirements that you see typically in loan documents like yours include financial information and auditors' reports, compliance certificates, notices of default, changes in credit rating, and matters relating to litigation and material contracts and or developments expected to have a material adverse effect.
Yeah, and I also know that I should review my obligations as a borrower to provide notices under the documents and check any deadlines by which I'm obligated to deliver that information. I'm told even where a grace period applies, a notice may still be required.
Well, that would be really cool of you, Mr. Landlord, if you were to provide us those type of notices. In fact, both of us should review the loan documents to determine what representations and warranties were included, such as material adverse effect and no default clauses.
Yeah, as I mentioned, I spoke to a bankruptcy attorney and she told me about those. And so, a material adverse effect, as she explained, it's generally defined as any development, event, condition, state of facts that have had or could reasonably be expected to have a material adverse effect on the business or the assets of the company, the financial conditions of the company, or result of operations on the subject party. A lot of different things that would preclude a borrower from performing its obligations under the agreement. And I think I'm supposed to notify you if something like that happens, at which point, you might be able to terminate this agreement.
Exactly. You have to notify us, right, Mr. Landlord? And as I mentioned, we will also need to look at providing you a short-term break on the required covenants and ratios like loan to value and debt service coverage. As you know, debt service coverage ratio, or what we in the banking world call DSCR, measures a borrower's ability to repay a debt based on the property's income and performance. Certainly, this crisis may affect your property's income. Also, we look at loan-to-value ratios that also measures risk based on the relationship of the loan amount and the value of the asset securing the debt. Once again, I'm sorry, Mr. Landlord, but perhaps this financial crisis will have an effect upon the value of Market Madness. So these are all things that we're going to have to look at.
Yeah, Mr. Banker, it'd be really great if you could just give me a short-term break on all those banking requirements. Maybe if we could defer interest payments until my tenants get back up and running. add that to the principal amount due under the loan, forget about all those reps and warranties. Don't look too hard at all those reporting requirements and just loosen up the ratios. And I think, that can benefit both of us. What do you think?
Well, Mr. Landlord, I'm so glad you came in today to discuss these issues with us before we had to track you down, because I think we both believe in the CC rider under these circumstances. It really shows us your commitment to your project, and your desire to be proactive speaks volumes to us. I really do think we have the underpinnings for the possibility of the potential of working through a forbearance agreement to get you through these economic crises. Now, only one last thing. I'll need to discuss this with the trustee.
Trustee, what are you talking about, the trustee? Can't you just make that decision?
Well, you see, Mr. Landlord, after Honky Tonk Bank originated the loan, it's now only servicing the loan. The loan has been put into a commercial mortgage-based security, or again, what we bankers call a CMBS. And I'll need to talk to the trustee for the investors in the underlying bonds to see if he subscribes to CCR. Not a problem, though. I should be able to get back to you and say maybe a month or so.
Yeah, no way. That's way too long. I think, under the circumstances, it's not business as usual, and we all better start to learn to communicate fast.
Thank you. That's the end of our presentation. I think we're moving into a Q&A session now.
Thanks, guys. I think that at this point we're checking to see if we have any questions from any viewers. Hold on just a moment and let's see what our questions are. So the first question that I have, I think, relates to Geof Vickers and Mark. Is there, so you've talked about these force majeure clauses. At this point, is there, are there certain contracts that people should be looking at? Are there ways to, to modify these at all at this point? Or if we're going into brand new contracts, I mean, for those who still have business out there, should they be, planning ahead for this type of pandemic going into the future?
Sure. Thanks, Dan. This is Geof. I can certainly give my perspective on this. And I'm looking at it from a business operations perspective because that's what my practice is. The contracts that I think where I would be the most concerned about it, particularly for my clients, are ones that are vendor and service provider related contracts that are key to business functionality services for the company itself. Everything from technology hosting agreements to personnel agreements, anything data related, anything related to the company's infrastructure or systems. If the company is one that has what I would say is a highly leveraged managed services type environment where they've outsourced a lot of services either to a kind of domestic onshore based vendor or an offshore based vendor. Those particular contracts I think are key. Certainly if they're run the business contracts, they're ones you want to look in. If you haven't gotten a notice of force majeure being triggered in the contract, they're ones you would want to look at and see what your remedies are in the contract, see what the force majeure clause says. I think going forward, those particular situations, they're certainly ones that I've actually seen outside of COVID. They're ones that I've seen very specific force majeure clauses in. I have a client, as an example, I have a client on the Gulf Coast that specifically in their vendor agreements, they carve out flooding and hurricanes as not being allowed to be force majeure events because they're not an if situation. It's really a when, because it's almost guaranteed that at some point, at least once a year, there's going to be some hurricane-related activity in the Gulf Coast. And so they, a number of years ago, really after Katrina and Rita, started putting that into their force majeure clauses. So I think it goes back to a few things that I mentioned during the presentation of the scope and coverage of the contract and the circumstances under which it's being entered into. So be specific, particularly if it's run the business related contracts. Mark, I don't know if you've got from a litigation perspective, if you have a different look on it. Mark, are you on mute?
Yes, I am. Thank you.
Sure.
Geof, I certainly agree with what you said in connection with what contracts to consider taking some kind of action, and I think you need to consider which contracts have you been substantially, potentially impaired in your ability to perform under, and certainly for a business that's been closed down, either completely or substantially reduced business as a result of the government pronouncements and things. You'll need to consider, for example, if you're a manufacturer and have been unable to manufacture goods, perhaps providing notice to your both your purchasers and your suppliers as far as not being able to perform under certain contracts or have a limited scope of being able to perform. We talked about leases being something that's been going to be affected, not only for retailers or restaurant companies, but particularly for those and many others. There's a whole host of contracts could be affected. Keep in mind, too, that for many businesses, they could be on both sides of this force majeure or contractual excuse side of the coin. They could be seeking to excuse performance on some contracts and having others approach them about being excused on others. So it's just something that it's a very fluid situation. You just have to evaluate things as you go along. Keep in mind and consider the factors we talked about considering and the practical issues, and consult with your counsel where appropriate.
Thanks, Mark and Geof. Here, I have a question for Mitch Boyarsky. So how do I confirm that an employee is really sick and tested positive for purposes of these paid sick and family medical leave act laws? And the part two of the question was, is there a form that I'm supposed to have the employee complete, like you would for normal FMLA?
Thanks, Ann. So under the traditional FMLA, an employee must complete and submit certification of healthcare provider that is signed by the treating physician, where they indicate what the reason for leave is. We don't really have that right now, and we're still waiting for the DOL to issue the regulations. Perhaps there might be a form, but for right now, there really is nothing. So if an employee tells you that they do need to leave, and it's because of one of the qualifying reasons, I would document it, but also provide it. And especially if the employee says, I am sick, or I have identified as symptomatic using HHS criteria, then I think you document that, and that would be the basis for providing the higher level of benefit.
Thanks, Mitch. And I think I have one more on Mitch's plate, so stay with me. This one asks, can an employee on an FMLA leave for serious health condition then get more leave for the emergency FMLA? So I guess that would be a question of, do they stack, or do they run contemporaneously?
Thanks, Ann. So before we get the DOL regulations, it's not really clear. Again, I would caution employers, if they are going to not grandfather the employee and allow that employee the whole new set of paid leave benefits. But to answer specifically one question, which is, if an employee is on a statutory leave of absence prior to April 1, that employee would be eligible, provided the employee worked the 30 days for the emergency leave or not for the paid leave prior to April 1. So that employee is eligible. And then in terms of whether the employee could stack or not, it's not clear. But I think the safer course is to treat that employee as eligible for the full 12 weeks. I hope that that helps.
Yeah, that's great. And I think the last question that I see here is for Gary and or Shane. So you talked about the business interruption insurance. And is that something that's normally a specific policy, or is that included in, for example, my broader general commercial liability type of insurance policy? And if it is there or in a separate policy, do I need to, is there a need at a certain point to be notifying someone?
So this is Gary, and I'm far from an insurance expert, but in my practice and otherwise, I've seen typically riders to policies providing for business interruption coverage. But to the last point, and I'll defer to Shane or it's other folks on this webinar who may have more knowledge, but I can tell you that notice is imperative in respect to all insurances, whether it's business interruption or otherwise. So if there's a notice, and there is a notice requirement in most policies that I've seen, in order to preserve the claim, you need to give notice to the parties identified in the policy to receive notice.
And this is Mark. I'm not a insurance coverage expert either, but I believe Gary's right. The business interruption insurance usually can often be done on a rider to another policy, whether general liability or other. As I understand it, it often requires some kind of physical damage or harm, but it's going to depend on the policy, and a question could be whether a COVID-19 virus could cause some physical harm or qualify there. So again, I'm far from an expert here, but we do have insurance coverage experts here at the firm that can advise companies and businesses on these issues.
Okay, great. And back to Mitch, you're back on the hot seat. I think a lot of people are dealing with employee issues, so we have quite a few questions for you. So one of the questions is, will you confirm that the 500 employee threshold, or under 500, for purposes of the Emergency Leave Act, is that aggregate or site specific? Sort of how do we measure that 500 employees?
It is really an employer-specific question, so you need to think about the facts and the description, the nature of your business. There's also in the DOL guidance that came out some discussion about the joint employer analysis, which I've spent a lot of time with clients going through now to determine whether, particularly if it's a private equity company that has portfolios, or those portfolios aggregated together with the parent or the PE firm. It really depends on how the entities integrate and operate. But I think if there is any gray area, again, it's better to assume that they're all going to be considered the same operating entity, such that it triggers the aggregate number. And whether you are above the 500 or below is then, more of a finite answer. So you really need to look across the organization. How are they functioning? Who is in charge? Who's handling human resources? But by and large, if they are really a single integrated operation, it's more likely you would do the aggregate. If there's clear distinctions in the nature of the operations, it may be possible to divvy them up and then to treat them as separate operations and separate employers. But you really need to do a fact-intensive analysis about that, which you might want to do with counsel simply to be able to assert the attorney-client privilege over that analysis if there was ever a legal challenge later on.
And I think those are great points, Mitch. And I'll add two more on that end, and that's that for those of you who have dealt with combining your related employers because they're a controlled group or an affiliated service group for other benefits reporting purposes, you should note that doesn't automatically force you to treat them as one entity for purposes of these laws. So what Mitch is getting at is you have to conduct this integrated employer analysis that the Department of Labor has specified 4 factors that you looked at, and it's the facts and circumstances. So it's not as black and white or cut and dried as what many of you may have dealt with a controlled group, or not that affiliated service group is cut and dried, but you may have previously dealt with. I have one last question here on, it sounds like the CARES Act, the payments that are being proposed to employees and the increase in unemployment benefits does that also only apply to employers with less than 500 employees? And I think I can take that. I don't think, and Mitch, correct me if I'm wrong, but the unemployment benefits, that's all employers and does not impact, from what we've seen so far, and is not limited. However, the loan funds that are going to be made available to businesses, that actually is what's strange is it's written as 500 or fewer, even though, so loans 500 or fewer, but when we were dealing with a more emergency paid sick leave and emergency FMLA, that was fewer than 500. So I expect that will be a glitch that gets corrected. But what's important to note is for those of you that are trying to make a determination of whether or not you try to claim your greater than or less than 500, this is where you're going to find it's kind of a double-edged sword, because you may want to try and combine entities, perhaps because you don't want to have to give this paid sick leave or paid FMLA. Because remember, even though you're getting reimbursed, it means that you could have 80% of your workers claiming this leave, and who's minding the store in a sense. But on the other edge of the sword is, if you go that route and now claim you're over 500, you've now removed yourself from eligibility for some of these loans. So, and note, if you're in the food services or accommodations industry, which is NAICS code starting with a 72, there are some special rules that apply to you where, especially for some of these loans, you may actually be able to measure your 500 employees based on each location. So check with your advisors on that. But there's a lot of different considerations that you need to be taking into account in any analysis. Looks like we're coming we just came up on 3 o'clock, and we want to be respectful of everyone's time here. So thank you for joining us. If you have any follow-up questions, we encourage you in the follow-up to this webinar or on your webinar page, you can send in any follow-up questions to us, and we will get back to you. But thank you very much for joining us, and good luck as you continue to try and deal with this pandemic.